pronunciation.
Bobby Block,
Mr.
correct.
Block, you
Well
are
done.
recognized. Thank you. And your handwriting is incredible.
Hey, it was actually my legislative director's whose handwriting
Okay.
is much better than mine.
Well done.
But I'll take that.
And you are an opponent, for the record.
Okay, good afternoon, Madam Chair, ranking members, and representatives. I'm Bobby Block. I'm the executive director of the First Amendment Foundation, and I'm here in opposition to HB 465, which as written represents not only an egregious threat to students' constitutional rights, but as others have pointed out, proposes turning Florida's universities into quasi-police agencies reporting students to federal authorities for little more than expressing their political views. And personally, I can't think of anything more un-American. I get that many folks are angry after hearing some university presidents muddle through testimony in Congress a few months back. And as someone who lost family in the Holocaust, I have no tolerance for anti-Semitism and people who incite others imminently to harm folks based on their race, religion, ethnicity, or politics do not enjoy my support or the protection of U.S. law. But expressions of support for ideas that we find abhorrent are protected under the First Amendment. This is the burden of the First Amendment. To put it another way, the First Amendment is about protecting speech we don't like, not about protecting speech we do. We've been here before, dozens of times, whether to allow members of the Klan to parade down Main Street or white supremacists to march on Charlottesville screaming Jews will not replace us. While most of us are horrified by these events, U.S. courts have consistently held, contrary to what has been said in this committee, that hate speech is often protected speech. And the best way to counter it is with good speech, not by outlawing it or cutting speakers' academic stipends. Which brings me to the issue at hand, which is stopping the promotion of terrorists. And let's be specific. We're only talking about foreign terrorists. Support for homegrown extremists get a pass in this bill. The term is vague, broad, and has been pointed out likely to result in this law being struck down. I fear the bill's true aim is about punishing student protest and speech. Otherwise, there is no need for this law. The U.S. Anti-Terrorism Act already makes it illegal for anybody in the United States or within the jurisdiction of the United States to knowingly provide material support for foreign terrorist groups. And the penalties are severe. If you believe our campuses are full of terrorist supporters, then charge them under the existing law rather than creating a new bad one to punishing them for saying what you don't like. But note, even the Anti-Terrorism Act draws a line between speech and action. In Holder v. Humanitarian Law Project from 2010, the U.S. Supreme Court ruled that the Anti-Terrorism Act has a firm line between advocacy and for terrorist groups and material support. Furthermore, the Supreme Court ruled that public universities can't act as HB 465 proposes.
Mr. Block, please bring it in.
Well, we're almost there. In the case Rosenberger versus V. Rector and Visitors of the University of Virginia, the Supreme Court found that UVA's refusal to fund a student organization based upon the organization's speech was illegal. HB 465 would punish advocacy and would force Florida's universities to violate the constitutional limits set forth by the Rosenberger case. All of you have sworn an oath to uphold the Constitution. If you pass 465, you'll only be adding to a slew of bad legislative ideas that have cost Florida taxpayers millions of dollars in legal fees before they were struck down for being vague, ill-advised, and unconstitutional. Please break this pattern, honor your oaths, and let this bill die the death it deserves. Thank you very much.
Thank you, Mr. Block. If you could just wait just a moment, Mr. Block. Vice Chair Beltran has a question for you.
Sure.
Thank you. You're recognized, Vice Chair.
Thank you, Chair, and thank you, sir, for being with us today and providing us the Holder case. That's an important case. In fact, I was going to ask if you were familiar with it, and then you mentioned it. So I'm at page 2729 of the Holder case, and it says, in this case, it was the PKK. They were training members how to use humanitarian and international law to peacefully resolve disputes. And then they teach PKK members how to petition various representative bodies, such as the UN for relief. So those look like speech to me. And the Supreme Court, Justice Roberts, upheld those the criminalization under the material support statute of those activities. So how can you distinguish our bill from that, please?
Because it goes on to say, and unfortunately I don't have it up with me, but I'm happy to talk to you offline, is it also says that there is a distinct difference between using these things that ultimately comes out, that actually provides material support, and a difference between pure advocacy, which just basically says, you think that they're justified in what they're doing. So that makes a distinction lower down in that case between material support and advocacy. And what you're quoting from is the material support part.
Did you have a follow-up, Vice Chair?
Yes,
You're recognized.
thank you. I mean, I guess isn't what we're talking about here is that these folks were teaching the PKK how to engage in advocacy?
Yeah, the problem is I don't know what you're talking about because you're using a term called promotion, which everyone here is noting it's impossible to distinguish what do you mean by promotion. Material support for terrorism is clearly outlined in U.S. federal statute. If that's what you think is going on, prosecute them. The penalties are really bad. If you don't like what they have to say and all they're doing is advocacy, let them be. Counter it with good speech. That's what we do in this country.
Thank you.
Thank you very much.